Thank you for joining us for today's webinar. Your client posted what? Top social media concerns for lawyers and clients, presented by Scott Maloof. My name is Stephanie Phelan. I'm a marketing manager at MyCase, and I will be your host today. First, I'd like to give you a few tips about participating on GoToWebinar. The webinar control panel is on the right-hand side of your screen. This is where you can control audio, chat with me, and submit questions. Please use the questions pane to submit your questions at any time during the webinar. I'll be collecting those questions and saving them to ask Scott at the end of his presentation, so please don't wait until the very end to shoot those over to me. Also, please note that these slides and the recording will be available by end of day tomorrow on the MyCase blog, and will also be emailed to all registrants. When you close your webinar today, a 4-question survey will pop up. All you have to do is answer a few of those questions and you will be entered to win a $100 Apple gift card. If you'd like to join the conversation on Twitter, the hashtag to use is #SocialForLawyers. This webinar has been approved by the Wyoming State Bar and the Florida Bar for 0.5 hours of general CLE credit. That's right, this is only a half-an-hour webinar today. If you are a Florida Bar member, note CLE course number 2196R to self-report your CLE. I will also send this information out on the GoToWebinar chat pane. Today's webinar is hosted by MyCase, so before we jump into things, I'd like to give you a quick overview. MyCase is a web-based law practice management software that takes care of your daily practice requirements for calendaring, contact management, document management and templates, time and billing, client communications, custom workflows, and more in one solution at a really affordable price. MyCase is priced for solo and small firms at just $39 a month per attorney and $29 a month per paralegal or support staff. We also offer MyCase websites for our customers. The cost to set up and build your website is only $500, and then there is a $50 per month maintenance fee. We use a modern professional design built for your firm. The websites contain social media and blog integration, and best of all, a client portal which is completely integrated with your MyCase software. So now you and your customers can log into MyCase directly from your own website. And now for a new feature, approved MyCase customers can accept payments directly from client checking accounts, also known as eCheck or ACH payments, for free with no third-party integration required. By linking MyCase's legal billing tools to your operating and trust accounts, you can seamlessly accept online payments into your MyCase account. We are also excited to announce that we are in the process of expanding payments to include a built-in credit card option. This service will be available to MyCase customers later in 2016. Last but not least, we enjoy hosting educational events for professionals in the legal industry, and that's why we're all here today. So let me tell you a little bit about our presenter. Scott Maloof is a social media attorney. He helps lawyers address all aspects of using social media and also helps organizations use social media for business, advising on corporate social media guidelines and practices. Scott writes and speaks extensively about legal and ethical issues raised by social media. He writes the social media law column in the New York Daily Record. He has also discussed the legal implications of social media use on NPR, on WBEZ in Chicago, in podcasts, in CLEs, and in presentations to business associations. He is a Rochester, New York native, received his BA from Hamilton College and his law degree from Vanderbilt University. When not on Twitter, his favorite social media platform, you can find him on his mountain bike or cooking up his favorite meal. MyCase's own Nikki Black is also known for her cooking and sharing the delicious meals she's made for dinner on Twitter. Scott and Nikki are good friends, and he claims in his own words that he is the better cook. Scott, I'm going to let you fend for yourself on that one and let you take it from here.
Thanks, Stephanie. And I'm sure we'll be hearing from Nikki about that issue soon. Hey, everybody. We've got 30 minutes, as Stephanie mentioned, and we've got some extended Q&A after that. So we've got a lot to jam in. It means we're not going to hit every point in each slide. So the slide deck has been made as a reference for you. So take a look at it when you get a few minutes of time to go through everything. There are hyperlinks on most of the pages, as well as 2 pages of hyperlinks at the end to ethics opinions, to the New York State Bar Association social media ethics guidelines, and the recently released social media and jury instructions guidelines. And as Stephanie said, feel free to live tweet or to tweet about this. The hashtag is social4lawyers, and my handle is @ScottMaloof. Okay, so let's jump right in. Why does social even matter? Advertising, business, obviously those are big deals. If you want to learn about that for lawyers, check out Guy's MyCase webinar, which is linked to right there. But for our purposes today, we're going to focus on the next 2 points. 1, social is a key communication and data storage tool for individuals and businesses. Things that used to be in paper are now on social media or up in the cloud. Secondarily, it's really important for us as attorneys to understand the legal implications of putting data in the cloud and how social media works day to day. We're going to talk about later in the webinar Oracle v. Google, which is a high-profile case going on right now, and how social media may be used in voir dire. Additionally, new ethics opinions are being released constantly, as well as cases. There at the bottom, I linked to one of Nikki's recent posts about a judge allowing Facebook as a tool for service. So that's why we're talking about it. Now, how is Facebook, or how is social media different? I just told you about, or let's actually do the poll question. Sorry about that. Poll question number 1. We want to learn a little bit about what you're interested in today. So I'm going to read it and then everybody vote. What social media platform do you most want to discuss today? Facebook, Twitter, LinkedIn, personal or company website, or something else? There are plenty of others. So please go ahead and vote now.
Okay, great. Thank you, Scott. And it looks like the votes are coming in. Please go ahead and wrap up with your vote. I'll close the polls and share our results. Okay, this is an overwhelming majority. 66% said Facebook would be the platform they'd like to discuss today. 8% said Twitter, 18% LinkedIn, 8% their personal or company website, and 1% other.
Okay, great. Thanks, everybody. We've got another poll question for you that we'll jump to now. And this is, what kinds of clients or stakeholders raise social media concerns for you? Individual clients, business clients, employees, or family of clients, others, or you're really not particularly familiar?
Okay, perfect. And thanks for voting, everyone. I will go ahead and close the polls. And our results. So the kinds of clients or stakeholders that raise social media concerns, again, a big majority here. 56% said individual clients, 17% business clients, 9% employees or family of clients, 7% other, 10% aren't quite sure. They put, I don't know. So individual clients is your big concern today, Scott.
All right, great. Thanks, everybody. Okay, so let's talk about how social media is different. We talked about paper. It's where paper records are now up there. But social media may contain the data that used to be on paper, but it's not paper. Social media is not electronic paper. Number of points here. The biggest one being there's a huge volume of information. First bullet point there, 90 pieces of content per month are posted by the average Facebook user. And so remember that. Or if any of you are using Facebook or other social media accounts, think about yourself, and if you were involved in litigation, how much time it would take to go through that social media in a case. Another thing to remember, social media, very different than paper, very different than email, is the posts continue to come. You can tell a client, don't post. You can say, please don't talk about the case, but they're going to continue to post on social media, and so you need to factor that into your calculations. Another thing, fast publishing and ephemeral data. Some of you are, you should remember, social media is quickly published, just as quickly it can be deleted, but also it can just as quickly be researched. I know some of you may be wondering, what are some tools that are out there to collect social media? We're going to talk about one in a second. And by the way, remember, if you're collecting the social media by yourself, I want you to always keep in mind authentication. You know, are you putting yourself in a position, especially if you're a smaller shop, that you are going to have to put yourself on the stand to authenticate it? If that's the case, find a different way to do it. So one of the tools that some folks have been using to collect is called Geophedia. And what Geophedia is it's geography-based. It looks at a particular location, and it says what social media posts have been made from that location. And it's a really good example of how quickly we can use social media tools to do research. So here is a slide, and this is a very unfortunate reference to the terrible attacks in Brussels. And this came to me, I would say, about 18 hours after that news broke. And what you're seeing is on the left is a picture of the terminal or the terminal area, and those upside down teardrops are the locations or approximate locations of social media posts. And the little squares are the Instagram logos. So they're telling you these are Instagram posts that were made in or near this particular location. As you can see, some of the roads are there, so you can know where it is in the physical world. On the right, that is one of the actual posts, the darker upside down teardrop from there, and you can see this is a representation of what that scene looked at. Really helpful when you're doing research or investigation, or very important in discovery, because you have the username, you have the time and date of posting, and you have additional info. And obviously you can use this to wheel and make additional discovery. So that's why it's really, really important to know that this is not paper. Next couple of points. I want to talk about social media is different because it encourages informality and authenticity, and in litigation and in business projects that can backfire. So what do I mean? Any of us who are working with business clients representing individuals involved in employment litigation or any kind of business issues or social, personal issues know that you've got far-flung teams that are knit together through these social media tools, particularly the ones I've highlighted here, chat platforms. There's Slack, Campfire is another one. There's one coming on board in beta testing for the legal world called Legaler, which is really a cool, interesting platform. And these platforms are really interesting because they let those teams work together 24/7. Someone at 11 o'clock at night can post something, another person in another time zone will see it the next morning very quickly. And they're easy to do, easy to use. But the downside is a lot of these platforms, particularly how the users are using them, not to stereotype generations, but a younger user may be more susceptible to this, or anybody involved in media or in marketing more susceptible to being really informal and using the tool as a bonding tool. They can't get together over a beer or a cup of coffee, so they use the tool to do it. And the water cooler remarks, off-color remarks that would have been said in the past at an event and gone away in the ether, now they're stored and they're searchable. And that can have huge, huge implications. And this is true of these chat platforms as well as social. So if you're not familiar, recently we had a case, Hulk Hogan versus Gawker Media. Gawker received a sex tape anonymously of Hulk Hogan, posted 9 seconds of that sex tape with some commentary. Hulk Hogan sued Gawker for invasion of privacy for posting this anonymous sex tape. Hulk Hogan won that case, and the case is Bolia v. Gawker if you're looking it up. Got $60 million for emotional distress, $55 million for economic. I want to stop there and say that's $15 million more than he was asking for. He was actually asking for $100 million. In addition, the jury awarded $25.1 million in punies. And let's focus on the smallest amount of this award, the .1. $100,000 of the punitive awards was awarded against a Gawker editor who has $27,000 in student debt. So what explains this huge, huge award, which I will admit this is early days. Clearly we're going to hear from appellate courts on these issues. I would offer that a big part of this was the chat application used by Gawker known as Campfire. And this case just came down earlier this month. This Campfire application, very social feel to it, a lot of social features. The Gawker editors, though, came across as mean, having humor in it that fell very flat when you read it maybe a couple of days later, but very, very flat when utilized in litigation, be it depositions and other things. They also came across as crude and heartless. Now, that may be some reason that explains it. But in this case, also, it's really hard to square their primary legal defense of First Amendment, this is core First Amendment, the public is interested in it, with what you saw on the chat platform. And so that's how social is applied in litigation. That's why you need to know about the use of this stuff. Okay. Sorry, I'm jumping forward to our next poll question. Tell us a little bit about what kinds of cases raise social media law concerns for you. 1, personal injury. 2, employment or commercial lit. 3, family law. 4, criminal. Or 5, other.
Okay, thank you, Scott. So please go ahead and place those votes now, and I will close the poll. Okay, and our results. The kinds of cases what kinds of cases raise social media law concerns for you? 14% said personal injuries, 29% said employment or commercial litigation, and tied with that, 29% family law, 10% criminal law, and 17% other. Is that about what you were expecting to see, Scott?
Sure, and that's not surprising. I mean, those areas can be really cutting edge. So let's talk about what should you do when these cases come in the door. First steps. 1, think about, how is social going to be relevant to your case? I've listed some examples there. The classic being personal injury. Are posts or pictures made after the date of the accident consistent with what the person claims their physical injury is? So think about your case and what social might do. Look at the examples there. But 2, you've got to modify your process because social media discovery is very iterative. We're still early days in how we do this because 1, the cases are new and we keep getting new case law every few months. But 2, the platform's continuously morphing and changing. Think about LinkedIn. LinkedIn has a lot of tools now, liking posts, commenting on posts that were pulled from Facebook. Okay, so the platforms are changing. But I also want to talk about really quickly the risk of all in your practice. If you've got a lot of forms and you're asking for all social media in discovery, that can be a really big problem. It's a good example of the challenge here. Because we've seen when you ask for all social media or you ask for all social media after, say, the date of an injury or date of separation from employment, judges and plaintiff's attorneys are pushing back and saying, wait a minute, that's a lot of data and maybe it's not relevant, maybe it's not, and maybe it's burdensome to go through it. So be aware of that. Secondly, modifying your process, you may have to tweak your forms. And so think about that and say, what changes should I make? Now, I know a lot of folks have billing restrictions that, it's very hard to do that, but I would point to your clients and say, look, 1, we're making these changes because it's going to head off a discovery dispute later that's going to cost you more money. But 2, we're also doing this because we're going to get better results. This is an iterative process. I need to learn back and forth. I need to change how we review things. So by making this change up front and you paying for it, we're going to save quite a bit of money. Okay. Next step I want you guys to look at is your client, okay? Do the due diligence. Yes, we've all heard, do a Google search on them, but don't reduce your client to just a Google search. When they're sitting there, ask them, what platform is most popular with you? If it's a personal injury case or a family law case, that may be Facebook. If it's an employment case, that might be LinkedIn. And so you need to think about that. 2, I want to jump to one point really, really important, which is friends, okay? And friends may be an access point to data that you otherwise think is private, okay? And let's walk through how that can happen. First of all, privacy settings. Every social media site generally has some privacy settings, all the way from the entire world can see it down to only the account owner can see it, and many steps in between. So that's the first issue, is figuring out what are the settings on the particular accounts that are relevant. And why is that relevant in litigation or any matter? Because it's going to prevent your opponent from seeing it and just going on the web. And 2, as we know, and if you don't, this is the ethical standard in most situations, the ethics rules prevent your opponent from sending a fake friend request. Joe Smith can't send a request as Jane Doe. Or even reaching out to somebody who they know is represented. Can't do that. And we've got to look at the ethics opinions at the end to talk about that. But even if you've taken those steps, it doesn't mean the door is closed. Those settings themselves don't close the door. And let me give you an example. What if the supervisor is the friend of the employees? I know most employers say don't do it, but it happens. Or you have co-employees who are friends of each other. If one of those folks is friendly to your opponent's counsel, or the opponent's counsel picks up the phone and says, hey, supervisor, may I shoulder surf your Facebook account, then despite those privacy settings, that access is going to happen and they're going to see those things. And this came up in the case I mentioned, the Oracle v. Google case, where Judge Alsup asked the parties, by the way, the investigators you're using, if they have friend-of-friend access to the jurors by chance, for some reason, maybe they're friends of friends at school or something of that, are you going to, quote, exploit it? Judge's words. And so you have to be really aware of, okay, this is out there, this is a possibility, but also the downstream. How's the judge going to look at this? How are juries going to look at this, and how are we going to settle this? Finally, even if your opponent is not looking for this information, even if you've got all the settings locked up, you got to be aware. Friends in social situations or employees are often dropping the dime, and a source of information in HR may be fellow employees who say, hey, this person's out in disability, but look what they're posting on their Facebook page. One quick reference, check out A Good Second Impression. That's my article from the Daily Record about ethics opinions and changing social media settings. Okay, let's jump to, you've done the due diligence on your client. What about the due diligence on the court? First couple things, if social's coming up and if you think you're going to need judicial intervention, one, understand, what does your judge know about social? It's a really important question because most judges do not have a ton of knowledge on social media. There's a really good reason, of course, because judges don't want to be conflicted out of a case. So they've got some judicial ethics that may prevent them from getting into the case. Also PR risks. Judges judge 24/7, so a lot of reasons a judge may not be on there. Second, cost control. Know your judge, and is there a tool that they're willing to use to control costs? The cost can mount very quickly with electronic discovery and social media discovery. So look at where, the courts you're in and say, is there something we should do that this judge can help us with to control costs? And finally, I've made a couple of references to voir dire and juror social media. So what I want to do now is talk specifically about Oracle v. Google. Basically, this case is going on right now, Northern District of California, and if memory serves, it's a retrial. And early this month, the parties went to Judge Alsup and they said, Judge, we have agreed on a juror questionnaire, and they did what you're always supposed to do. You agree with your opponent, you present it. Judge Alsup said, one, I've looked at your juror questionnaire. I don't think it's going to save any time. Two, I think your juror questionnaire is actually laying the groundwork for a second bite at the apple. If one of you gets an outcome you're not happy with, you're going to use the information revealed by the questionnaire and by your searches of the jurors on the internet and on social media to gin up or generate some alleged fib or omission that the juror should have made or should have said or had acted upon, and thus the result should be overturned. And then the judge took a third step and went even farther and said, by the way, I'm going to ask you, I'm considering banning all internet and social media research. I want you parties to justify to me why we should do it and what are the what's the law in this area and what are the ethics in this area. As we're speaking right now, we have not seen a final decision from the judge, but we've seen a really intense back and forth with the judge asking the parties questions. And the parties really having a tough time, in my opinion, my humble opinion, no dog in this fight, answering those questions. And it's a really, really tough thing to do. So I ask you and tell you, go take a look at that if you're considering voir dire with your jurors. Also, I've listed 2A through E. Those are the typical concerns for judges. Efficiency of the voir dire, juror privacy, really big issues. If you intend to do this, look at those concerns, understand your judge, and lay the groundwork that addresses both before you propose doing it. It's a good thing to do. I think it adds a lot of value, but just lay that groundwork. Okay, we're going to turn to business issues now. Poll question number 4. What size businesses or not-for-profits do you serve? 1 to 10 employees, 11 to 25, 26 to 100, 100 to 1,000, or 1,000 plus. Please go ahead and vote now.
Okay, thank you, Scott. And the votes are coming in. If everyone can please go ahead and place your final poll vote. Okay, looks like majority has voted, and we'll close. Okay, another big majority here. So it seems like people are working with smaller businesses. 49% said 1 to 10 employees. 13% said 11 to 25. 16% say 26 to 100. 13% in the 100 to 1,000 range. And a smaller percentage, so 10% with the 1,000 employees plus.
All right, great. Okay, so let's talk about what are the business social media concerns. Usually you do the takeaways at the end. We're going to start with them. I want to help you in talking to your clients about these issues. First, the clients are going to say, well, these accounts are free. Why do I have to spend money on you, the attorney? I would say just answer with example. Everybody's got a local fast food joint, or there's always one in some state that the employees have posted disgusting pictures on social media, and ask your client, hey, would you want to eat at that business? Would you want to invest in that particular location? Two, you can point to US Air. About a year or two ago, they had an employee, professional social media employee, who posted a pornographic image on the US Air Twitter account, clearly undermining the brand. So that's why, even though it's free, the problems in dealing with them are not free. And then empower via guidance. What do I mean by that? It refers to the picture of having fun. You know, as attorneys, we always get this reputation. We say no. What I'd say is social media is pretty hip. It's really becoming a core business competency, and it's technologically involved. So don't just say no, don't do this, but find creative ways to reduce risk and achieve the client goal. We're going to talk about how to do that a little bit, but let's lay the legal groundwork. What laws should you be looking at? At the very bottom, FTC, focused on social media. Check out the link there. Basically, Lord & Taylor had paid or given consideration to some Instagrammers who were really well known for fashion to promote a dress. And the FTC came down very hard on that, amongst many other activities. Big issue is monitoring. You know, if the FTC wants to monitor you, it can make it really hard to use social, but check that one out. But I want to talk about copyright, because I think that's the #1 issue. And why is it #1? Let me tell you, social media and the internet are very much changing, no surprise, but they're moving to more images, more video. Okay, so away from text to image and video. And they're moving to more emotive content. They really want things, people really want things that hook them and draw on their emotions. But I'll tell you, that content, really hard to create, but it sure is easy to steal. And so you need to instruct your clients that just because you found it on the web doesn't mean you can use it. Because frankly, that often is people's view that, well, I Googled it. That is literally the answer. I Googled it, so why can't I use it? You need to instruct them on the risks of copyright. Secondly, anyone managing those accounts, especially we talked about businesses that are smaller, often it's handed off to a younger employee or maybe a part-time employee. They get very, very little instruction on how to manage these accounts and what the legal issues are. Let me just tell you very quickly. Here in Rochester is a national company that has many local social media accounts for their local spots. And so what they do is they let the entry-level employee run the local account. And I asked one of those entry-level employees, I said, hey, what instruction did you get for running this local account for a national business? And the response was, my boss told me, quote, don't embarrass us. And that's it. And so frankly, that's more the norm. And you need to be aware of that when you're advising your clients, and this is a big risk. Secondly, let's look at a few more legal issues that come up that I think are really important for all employers. We'll go through these now. Password protection. That is just a catch-all phrase. 27 states have them. There's a federal one that's been proposed, nothing solid yet, for protecting employee and applicant as well, social media. And what it means is an employer cannot ask an applicant or employee for a password or a username, can't demand to be friended, can't request content. Obviously some exceptions. But you have to be aware of that if you're developing a practice or a process with the client. Do you have a password protection? National Labor Relations Board, what's its guidance is to protect employees and allow them to talk about, one of the big ones is terms and conditions of employment. What are their wages? How are they being treated? And if memory serves, their threshold is that starts at 5 employees. Once you have 5 or more employees, you're subject to NLRB guidance. And they have found quite a bit of traction with issuing guidance on social media policies. I believe just last week, a local Chipotle, and it may have been a regional Chipotle policy, was overturned, and the employee was offered back wages because the social media policy that he allegedly violated NLRB guidance. Wage and hour. Let's go back to that entry-level employee. First thing, when they got home and said, hey, I'm doing this, a family member said, are you getting paid for those posts you make when you're not at work? Great example, which is 24/7 workplace. Social media can be done from a phone anywhere. But is that account, being posted at 11 o'clock here, time is not being recorded, and maybe if you got multiple managers, all of a sudden 3 years later, you have a lot of unrecorded time that was expected, and now you're subject to a lot of those wage and hour prescriptions. So be aware of that. And finally, BYOD. All that means is accessing employer data on your own device. Employers, we all try and protect our data in our systems, but you let employees use their tablets, their phones to go in, grab the data, respond, send the email, do whatever they got to do, and then it raises 2 big issues. One, is that data being copied to the employee's cloud? Do they have their own Dropbox account where they're going to keep the spreadsheet and work on it at home? And 2, what if they lose it? I mean, if your client has any kind of HIPAA or medical data or financial services data and that device is lost, that account is breached, it may cause you. It's all related because these practices all come together. So those are your employment law concerns. Finally, business client first steps. We've talked a lot. We need a little bit of break, I think. I just want to point to that headline about ESPN suspending Keith Olbermann. Check out these tweets, either now as we're talking or at your leisure, and ask yourself, was there any reason for Keith Olbermann to be engaged in this discussion? And this goes to point 2B, which is plan for stupidity. Olbermann should have known better, but he couldn't resist. That is going to happen to your client. So similar to that litigation stage, what are you going to ask when the client walks in the door? I've got 1A through E, a lot of questions, but I would ask 2 big ones, which is 1, what's the budget for this? And it's a really great question because you can understand how big a priority it is for your client. But 2, I would jump quickly to D and E as well, which is, client, explain to me what's a huge win, what's a huge loss, and then that way you can get a better feeling for what the client intends to do, what risks they're willing to take, as well as what laws above are implicated. Okay, so it's about 2:33, and we've got time for questions. If we have questions, Stephanie, I turn it over to you.
Yes, thank you, Scott. That last example was really interesting. So thank you for a wonderful presentation. For those of you who have to leave us now, please take note of 3 things quickly. MyCase offers a 30-day free trial, and since you attended this webinar today, you get a bonus discount. So note that promo code 10SOC, as in social, 16, for when you activate your account. And secondly, when you close your webinar, a 4-question survey will pop up. All it takes is answering these questions, and you'll be entered to win a $100 Apple gift card, so definitely worth your time. And if you're a Florida Bar member, note that CLE course number again, 2196R, to self-report your CLE. And a few of you have inquired. Yes, you will receive an email tomorrow with a link to the MyCase blog where you'll have these slides, the webinar recording, and the Apple gift card winner. And now I'm going to turn it over to some of these questions, Scott.
Sure.
Okay, first one. What type of liability do you have when linking to third-party sites? For example, statements made on third-party sites. Do they become your statements for referring to them, or can they just be viewed as informational?
It's funny. That's a great question. 1, highly fact-driven, and so it's really hard to get a definitive answer there. If you're, first of all, it depends. What's your link say? I mean, the link itself, now we're in a position where we've got hyperlinks where, it doesn't just say link. It might, you could have something that says link to more info. That's pretty innocuous. Versus, check out how Hulk Hogan, ripped off my client. So the first thing is to say, well, what's in that statement? The second part of that is link liability. We've seen courts have been pretty strong to say, if you're merely linking, oftentimes we're not going to see a liability merely for the linking to it. So I'd say there's some cases you can rely on. You may have a 230 defense, or if it's a copyright issue, like a fair use defense. But the other thing, the final thing is, okay, but are there any other? We've looked at law, we've looked at the language, but are there any other prescriptions or proscriptions in the sense of what other agreements do you have? So, for example, if it's you've agreed to ethics, the ethics rules we have, and these are client. Not even secrets, but just unflattering things to a client. There may be a violation there. Or, if you've got a client, if the client is someone who's agreed in a workplace to say, well, I'm not going to let any employer information leak out. I would argue by the mere posting of the links, you may have violated that. So I think those are kind of all the metrics you're going to be looking at of how are these things there. And so not a easy answer to give because it's so fact driven.
Okay, great. And this is somewhat in the same channel there. For Twitter, for your retweets, are you held liable for views expressed in them?
That's an interesting question. Again, it's a real challenge because it depends on what's the original tweet say and what's the context. There's no way to easily say, oh, a retweet is never going to generate any liability for you. I'll give you an example. We had a Katherine Heigl case, and this is not defamation, but this is publicity rights. Katherine Heigl was out with a Duane Reade bag, and if memory serves, she was just walking across the street, and somebody took a picture of it, and they posted that on Twitter. And then Duane Reade, I believe, retweeted that image and said something along the lines of, even Katie Heigl loves to shop at Duane Reade. So clearly, taking her image, taking her persona, and saying, hey, public, she likes it, you should like it too. We didn't get any case law on that. We didn't get any guidance on that, but the case did settle. And so, and I believe that Duane Reade had made a payment. And oftentimes, it depends on the company, but some companies have said, you know what, we might allow a favorite, saying, oh, I like that tweet, but we won't allow a retweet of it because you're not then speaking. Also remember, a retweet spreads it to many different people. So, for example, Nikki Black, we mentioned Nikki at the top. Nikki has many more Twitter followers than I do. So let's say I tweet something, it's defamatory, blah, 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 blah. I'm on the hook, but Nikki retweets it. There's a big difference there because Nikki's got a big, broader reach. So even if we say, well, Nikki, you didn't speak, you didn't say anything, but you spread it a lot farther. So again, it's all going to be very context driven, but I would say they're very different, and you can't just say, oh, retweets are cool, and they're covered.
Okay, great answer. Okay, next question. How does the third-party doctrine relate to voir dire or juror search? For example, a lawyer is friends with someone who's friends with a juror. That juror posts something that could affect their attitude of the case, and the friend shares it with the lawyer. Is this the same as publicly shared? Did you get that question?
Yeah, I'm going to play with the facts a little bit on that one. But I mean, let's do this. Let's start with our ethical duties, okay? And again, I go back to that Google v. Oracle case, Judge Alsop's decision. I think his order, maybe March 13th, where he specifically said, you have ethical obligations to notify the court if you believe the jurors are not following our instructions. So that's the order. So that's in there. But two, we've seen that. The social media ethics guidelines that you see on the screen specifically have a section addressing this. And you have an obligation as an officer of the court when you have some evidence, and that some evidence, I hesitate there because, boy, it's really hard to determine when you've really specifically hit the point where you want to bring it to the court's attention. You have that evidence that a juror is not following the guideline, the instructions they've been given. The juror, you think they're doing outside research, they're commenting on the case. When you bring that to the judge's attention, you have an independent duty. So regardless of how it came to you, you have these obligations to do that. Where it gets hinky is, we have there was a case here in New York, Second Circuit case, where you had a juror who was an attorney who was, I believe, was either disbarred or had lost their license, but had a lot of legal knowledge. And the person lied and just said, no, I have no legal training. And, the interesting part was the attorneys in the case were doing kind of this rolling research into all the jurors and this one, and they kept getting more info and they kept getting more info. And, the judge had a much earlier threshold than maybe others would about when they had to reveal that. So that's why you got to walk through that before the case even starts and say, okay, when do I want that? And be aware, when would I want to reveal that? Like, what's the triggering factor? Like names, boy, you do a Facebook search for names, and if somebody's got a really common name, you're going to find a lot of people. That can be very difficult to know, is this person our juror, especially if the picture doesn't match them. And then be aware, again, judges, very different set of standards. They want this trial to go the correct way. They want to know this stuff early on, whereas you as a litigant and your obligations to your client may say, we're winning. Don't tell them. You want to kind of diffuse that as early on as you can in the process and say, hey, client, I have no choice. So this is a risk that's fully on you. And again, that's a good way to get the client to understand it, cover yourself. Stephanie, whoever asked if they want to shoot more questions, I'm happy to elucidate on that more.
Okay, perfect. Okay, so it looks like we have time for one last question. Scott? And this person started out by saying, Scott is a rock star in social media law, so thought I'd
that must be that. Nikki.
It wasn't Nikki. Does he have recommendations on vendors who can defensively collect social media for legal disputes?
I think the first thing I would tell folks to do is it's really, really one of those things where you got to look at your cases and set your budget and say, what's my budget here? What's my staffing level? And what I mean is, for example, like screenshots. Screenshots get a lot of grief, and people say, oh, this is terrible. But you know what? We have a lot of family law practitioners on, a lot of criminal law practitioners. You know what? If it's a small case and you don't have the budget for a vendor, then maybe screenshots would be sufficient. And then on the flip side, if it's an employment case, you know what? Talk to your local e-discovery shop. And I'm not trying to say, don't look at these, but talk to your local e-discovery shop if you've got a budget and build that relationship. And because what you're really trying to do is not just pick a vendor. You're really trying to do is say, let's say there are 20 social media accounts or 20 websites you want to collect. How do we build that process where we knock 10 of them out? And what that means is you as the attorney are talking to your opponent, or you're looking at this case with the client and saying, how do we say some of these are not relevant? Because the best and the cheapest way to do this is to not have to collect it at all. But with the caveat that social media is a little bit out in the wild, so you need to clamp down on it. So that's one, the two ways. And then there's Geopedia is one I looked at. Hanzo is another one that folks can look at for those kind of collections, Hanzo Archives. Really interesting because they kind of had academic roots, and so they're really, really good on that preservation aspect. The other thing is affidavits. I know we're getting up on time, but I'll just say, who's doing these affidavits for you? Think that through, because it's not just, oh, pick a technology and let it go. It's remember, it's a very iterative process, and you need all those things, the affidavit, the technology, the knocking things out, and the cost savings.
Okay, excellent. Well, we're going to call that a wrap for now. And thank you to everyone who has joined us today. And thank you, Scott, for an entertaining and informative webinar. Thank you so much for joining us today.
Well, thanks, everybody. And thank you, Stephanie.
Okay. Bye-bye, everyone.